No. Hey, how's everybody doing right now? Coming at you live from Dolly Parton's tour bus. I like that, huh? That's her bed right there. Don't ask where she is. I'll let you know when I see her. We'll be ending that stream quickly. Anyway, there we go. No, we don't go. I just thought that was funny. Guys, how are you beautiful tubers doing today? I hope you are well. Now I got the lights on. Sorry. Freckles says, I look too pale to be on this thing. Anyway, guys, I want you to do something for me. I want you to think of 3 things. Okay? Think of 3 things that you are thankful for. Just think of 3 things you're thankful for. Hashtag TYG and turn it up. How's everybody doing today? We are rocking and rolling. Oh, wait a second. Oh, that's my wife. Hit that. That's somebody's dummy. I don't have volume, which is usually a thing here. So, anyway, but no, oh, wait a second. I know what I forgot. Hey, this is going to be important. It's going to be so important. I've got to pull that up. Sorry. I forgot to, because I've had this pulled up on my phone and I need it pulled up here. All right. Make sure I got tonight's literature pulled up, ready to go. Rock and roll. So this is the latest filing tonight. By the way, let's say hi to everybody real quick. Do a little hellos. I'm a little late, so I'm going to start halfway with Rickles64. How you doing? We need to get all these creators to stop using Tug's watch. I don't know what kind of watch Tug wears. Mine has no screen. So anyway, hopefully he's got a better watch than I do, right? How you doing, bud? Wait, hold on. Where'd it go? Where'd it go? Oh, it moved. It moved. We got more things. Mama Cuddles. Oh, hello. I like that name. Mama Cuddles. How you doing, Mama Cuddles? You come by here often? You should. Tammy Bogart, how's it going? 2 for 2. How are you, babe? Hey, Shane Reynolds. Shane Reynolds. Whoops. White Rabbit came in with us today. Y'all, Shane gave me this. This was Friday Night Live. And she came in and she brings this in like this. I was like, oh, yeah, we were talking about that. And I was like, by the way, where's the box? She said, oh, it's in here. She went and opened this again. I was like, she could have done. She could have cleaned it for me. She could have been like, oh, I'm going to be nice. I'm going to clean this. I'm do this. I need to get some more stickers. Oh, there's a microphone right there. Who knew? Anyway. Let's see here. Let's get going. T-Rex, how's it going? 80s Music Man, how are you doing? Daniel Bates Sports Highlights. Venom. How you doing? Oh boy, Venom's scary. I like Venom. It's a good movie, I thought. Donna Ralph, how are you? Yamaha Biker. You are such a dork. Well, you know. Stacy Schmidt, how's it going? Deborah Kintai. Wow. The TIGH got me thinking about thighs, and I got messing me up with your name, Deborah. I'm sorry. I apologize. Thank you so much. Cindy Brown, how are you? What's up? Cindy Brown sounds like Charlie Brown. Cindy Brown. Donna Ralph, how are you doing? Angie, what's up? Jeff Montgomery, what's happening, man? Sweet Fly, how you doing, babe? I'm trying to go through real fast, so I know I'll probably be skipping over people. I apologize for it. Miami Spice, what's up? Wait, somebody said something about Miami Spice, I thought. And I was like, yeah, it's spicy, all right. That's her. Thank you, Lou. How you doing, babe? See for two give 10 memberships. Thank you so much. What that means, if you're a new member, you go to the members thing tab. Click it. There's a link to Discord. Come hang out with us. Oh, I wasn't taking my shirt off, by the way. Sorry. It was like this, and God, like, sorry. Guys, I woke up feeling like I had a Rona headache, and I apologize for that. I was not doing good. But anyway, all this silliness aside, thank you for two. All right, let's see here. Someone was talking spice about me. Yeah, it was awesome. Cindy Protime, how you doing? What again? Again? What are we doing again? Oh man. So like my ears are clogged up. I didn't know. I haven't talked today. So like I woke up, didn't sleep again last night. So again, didn't sleep. Went up this morning, got White Rabbit a bacon, egg, and cheese biscuit. And woke up. No, I didn't go to sleep. So went out and got one like at 7 a.m. And then came back. I think I fell asleep like around 9, and then my phone started ringing at 10:30, and I was just this. Finally, I got up and I walked downstairs. It was like 2 o'clock. And I was like, honey, I was like, I'm not feeling good, but it's going away. We're getting better. Anyway, guys, please make sure you are subscribed, because there's a lot of Muppet accounts. It looks like. Make sure your Muppets subscribe too. It helps. Every little bit helps. Oh, take a little bit more of my heart, baby. Take a look. Hold on. Why am I inviting somebody? And boom. Here we go. Let's get rid of this. Let's go right here. Hey, what's up, everybody? How you doing? Sinuses, y'all. Not sinuses. That Rona stuff I'm trying to get over. This says it is 23 pages. Let's see. United States. This is doesn't say who it's from here, so let's go down here and see. This is coming from a Miss Lee. Whoever Miss Lee is. And there we go. So here we go. I turned the comments off. I apologize, yeah. Linda Lazier, how you doing? What's up? Muppet Outdoors. That's cool. Look at that. That's a cool little thing. That's cool. I like that. I like all these. All right. Now, United States District Court, Northern District of Florida, Gainesville Division. Hales v. Cook. Defendant Lee's. Oh, it was written right here. Maybe I should have read that first. Lee's opposition to plaintiff's motion for leave to amend complaint to substitute party. Do what now? That's a motion? I don't think this is a motion. I don't think you can do this. Plaintiff's motion for leave. So she wants to be removed from the case for a bit. So to amend complaint. Opposition. Yeah. Okay. So this is an answer to I guess Jeremy had had changed his added to his complaint. I see what's happening now. I see what's happening. Yeah, it's not motion. That is the title of the complaint. This is her opposition, defendant Lee's opposition. I don't think this is how you would do it. You have to cite usually in the heading why you're opposing. Say like the 12B6, failure to state a cause for which relief can be granted. By the way, I really feel cheap by that. I feel like everybody's using that now, which means, and nobody's used that. Let me tell you about this. The entire time I've been in YouTube, nobody used that. Nobody uses that really in practice I've ever seen. I'm the only one that runs around my mouth saying, oh, hey, because I remember that specifically, the rules of civil procedure. I remember my professor just hammering that in, right? I don't know why it wasn't even on the exam. Now everybody's trying to do it. Anyway, that's a different thing. That's totally different. Hey, Jenny, 8675309. Hey, did you know that you wore the password at Dollywood to get into my stuff? How do you get into expert stuff? Ask Jenny. It's her phone number. I'm sorry. Comes now, defendant Lee's respectfully submits his opposition to plaintiff's motion for leave to amend complaint to substitute party, document 63, and states as follows. Now, first of all, this looks like it's a pro se response. Court, I will read this very favorable, just like the courts would read it, very favorable. Okay, so even though it may sound off, it may not be part of the thing, whatever it is. Okay, I mean, it's not going to sound like a lawyer wrote this. And so instead of sitting there and like, look at that, she's not a lawyer. Well, congratulations, you didn't fall for the trap. But the courts do look at pro se litigants, okay, with a romantic eye, we'll say. A little tear of love, like a little, oh, bless. It's like your little cheesy your little head scratch like that, just like, oh, you're so cute. Okay. Now, so there's nothing wrong with being pro se. It's one of the great things about our systems that you are allowed to represent yourself. You are allowed to stand up in front of your fellow man and say your piece as facts that you, as well as you can state them. Grandma's grandkids taxi. Was it grandma's taxi? Grandkids taxi. How you doing? I haven't seen you. It feels like forever. All right, let's see here. Introduction. This lawsuit is not a genuine pursuit of justice. I hate the word justice. I knew a girl that I tried to set up a date with a guy. She was in the adult industry. Her name was Justice. But anyway, that's a different story. But yeah, because justice, people don't really have it right when they talk about it. It is yet another episode in Jeremy Hale's ongoing campaign to manufacture controversy, cultivate outrage. It's a monolopy or whatever, monolop, and monetize conflict for the benefit of a YouTube channel. Court doesn't care. Hales, a self-styled content creator, has made a practice of instigating public disputes, recorded selectively edited encounters, and then casting himself as a perennial victim before a large and devoted online audience. His pattern is clear: provoke, record, and then profit. This is kind of a nice story to it, It's kind of this. I mean, it's well written as far as that respect. It's well written as a legal document. using the legal process as a mere backdrop for generating attention and financial support. By the way, if you hear something, let me know. I'm playing with a compass. This way I always know I can always find my way to Dixie. I always keep a compass so I can find out how to get back to Dixie. My compass does not point north, point south. The defendants in this case are not malicious conspirators. They're independent online commentators and critics who, like Hales himself, participate in the robust and often heated public discourse that thrives on social media platforms. Hey, look at me. Their statements cited in Hales' amended complaint are plainly matters of opinion, satire, or rhetorical hyperbole, well within the norms of the YouTube community and the First Amendment protections. This is very nicely written. I like this. This is a good synopsis. Hey, Miss Lee, whoever you are, I don't know who you are, but hey, I'm expert. Like, when I talk about the Hales, can I just copy and paste this as my description? Because this sounds like a YouTube description. It's really nice. By the way, you guys, I know yesterday I was very harsh. I had a very strict rule about, don't make fun of people, don't call them names, stuff like that, everything else. Some people got upset by it and left. We're not as strict today. Okay. I mean, don't make fun of people though, because all that can come back and affect you. Okay. Somebody is watching this stream right now. Hey, Shizzy, what's happening, my man? What's happening, brother? How are you doing? Man, if you're here, I'd say, like, man, give me some skin, man. How you doing? This is what we doing here. We're like, give me some skin. And then we go like this to him. Oh, God, run around. So cute. Anyway, but yesterday was for your own protection, y'all. Okay. Ballstorm had a little bit of too good of a time with it. Hey, Rosalind Duke. There she is. Sue Scat, how you doing? Everybody wants you to know that hey, B Blazy, what's going on? Saturn. I don't know Lisa's daughter. I don't know who that is, but Saturn is a cool place because it has rings. I love that. I love Saturn. I also like the Saturn rockets. I think they're very amazing. But welcome to the chat. The defendants in wait a second. Saturn. Hey, how are you doing? Oh my gosh, thank you so much for stopping by, Saturn. That's so cool. Welcome to the chat. Everybody say hi to her. So we love her. Tell her we love her mom. Okay. She's really cool. And thank you for sharing her with us. We have a great time. So you'd see, I got one of those girls working. All right. Defendants in this case are not malicious conspirators. They're independent online commentators and critics like Hales himself, participate in robust, often heated scores. Their statements cited in Hales' mini complaint are plainly matters of opinion, satire, or rhetorical hyperbole. I got rid of that. Sorry. Hales' true motive is not to vindicate his reputation, but to silence criticism, control the narrative, and stoke the outrage that drives clicks and donations to his online thing. I have a problem with where's my thing? Boom. We're gonna change that. We're gonna highlighter. I hope that's highlighting today. Why is it not working? Why aren't you working? Wait, because I went to the wrong screen there. Why aren't you working? Yeah, yellow. Okay. All right, look. Work. Why don't this work? Oh, that's so upsetting here. Why don't you work? Come here, work. Don't tell me I have to do this without a red pen. We will underline. How's that sound? It won't let me. I'm so upset about this. All right. So anyway, Hale's true motive is not to vindicate reputation, but it sounds criticism. So what I was trying to underline here is that right here, there's a jump to, but there's no statement of facts. There's no doesn't point to any evidence to it. Yeah, how do you know the true motive of anybody? Recent events underscore this pattern. When a retired attorney, let me see what's happening over here. My chat was moving. It's got stopped. Sorry about that. Saturn messed it up. Diane, how you know rules are for thee, not for me? That is true. Diane gets to do whatever she wants to. Matter of fact, I'm going to make sure after this stream that Diane is super allowed to, because you know why? She is. Yeah, she is. Yeah, she is. Oh, thank you, Diane. Thank you so much. I love it. I love it. Elfie, that's funny. Okay. Oh, whoops, hang on. I'm still in chat, and I'm not over there. All right, there you go. Recent events underscore this pattern. When a retired attorney and mother of four merely gave an interview to someone critical of Hales, she became the target of a coordinated harassment campaign by Hales and his followers, prompted and celebrated on his channel. Has nothing to do with Miss Lee's case here. I don't even know who this is. I would strike all this out. I have no idea who she's talking about or anything. This has nothing to do with why you should be removed from this complaint. Why are you talking about a third person? Why? I mean, okay, look, when a retired attorney and mother of four, okay, well, when a U.S. Army veteran dad, father of 17, well, who's that? I don't know. I just started spouting off words. I don't know what that means. This is, please don't do stuff like this. The litigation before the court is no different. Hales has weaponized the court system, turning legal filings into fodder for his videos, all while soliciting and receiving tens of thousands of dollars in donations under the guise of defending himself from attacks. This is not the conduct of a wronged individual seeking justice. It's the calculated strategy of a digital provocateur exploiting the legal system for views, influence, and profit. This sounds like an opening argument statement. This is the problem with getting your law license from Law and Order. Okay. It's like law. Yeah, I'll have fries with that too. Don't watch TV and think you're an attorney. For these reasons, the court should view Hale's claims with the skepticism warranted, and the legal process is conscripted, and is conscripted as a stage prop for online entertainment rather than a forum for the resolution of legitimate grievances. What? For these reasons, the court should view Hale's claims skepticism warranted, but the legal process is conscripted as a stage for profit and resolution of legitimate grievances, rather than a forum for the resolution of legitimate grievances. Wow, that'd been really cool if she'd used the, I believe it was Justice Harding that said the First Amendment is the marketplace of ideas. That'd been a very intelligent way of saying the same thing. It's the marketplace of ideas. Now, look at that Supreme Court case up. This is not conclusive to this case. But also others in Florida are experiencing plaintiff Hales conduct instated by plaintiff, whoever this is, against defendant Hales in case blah, 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 as Exhibit A. Plaintiff, why are we talking about this person? Are you the attorney for this person? In her Second Amendment complaint, the following states in her second, who cares what she states in her second one? We've lost focus. We have lost focus. This is about you, Miss Lee. Talk about yourself. Don't talk about some third-party participant. Who knows who this is? So you're talking about a separate lawsuit by a third party. Do you realize that that has nothing to do? Oh, in a different court system too. This has nothing to do with you, babe. Okay, who cares whatever happens there? That's none of your business. It's none of your business. What does matter is what happens to you when you are addressing the court saying this. Whoa, I'm being sued. This is what's going on. You talk about yourself. You don't talk about some other case in some other court with some other person. Sue Scott. Is she a soft sieve? It does read like that now. Oh my gosh. Defendants are misleading the public while presenting themselves as advocates for transparency and truth. Defendant Hales has orchestrated a consortium. This has nothing to do with this case. It has nothing to do with any of this. The data analysis shows the creators who align themselves with Hales. Again, now we're entering data analysis, which this is that case I read yesterday, isn't it? There's data analysis that wasn't presented anywhere as evidence. There's no data analysis. This is a fiction. I mean, right? Oh, look, that highlights. Yeah, sure, that highlights up there, but you won't highlight what I want down here. Great. Oh, and it underlines. Oh, I hate that. So mad. Anyway, this isn't true. None of this matters. None of it. Don't talk about him or her. I mean, you. Why are you bringing up these people? Please don't. This is again from the other case. This pattern of behavior extends beyond simple online rivalry. It constitutes a systematic campaign manipulation. Did I miss something somewhere? I don't think so. Sorry. Maybe I did. I did miss it. Hey, Rickles. Thank you so much. Hey, Rickles. Here you go. This goes with it, what you're saying. Competence. Wiggle, 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 wiggle. Wait. Check this out.
You're trying to say Jesus Christ can't hit a curveball?
Thanks, Rickles. Sorry, guys. That was funny. Right. Do you like Lego, Saturn? Because they have a Lego Captain America shield that I find fascinating. Don't know why. Anyway, sorry. Just a big kid. The pattern of behavior extends beyond simple online rivalry. It constitutes a systematic. Hang on a second. Let me make sure. I got new comments I'm having. How you doing, the Barnell? What's up? Hey, check this out. Look what crap. Hang on a second. Well, maybe not. I'm falling. Look what Broken Baker brought me from Denmark. Because it's always a chicken gets us in trouble at Dollywood. But don't ask. Sue's got soft sieve. We need to have a soft sieve thing. It'll be like we do. I don't know. It's like soft sieve. You know, something like that. Oh, wait a second. Look, we can do this. I'm gonna mess this up. Okay, watch this. Look, it's gonna be. Oh wait, that's not right. No, I can't do it. That's not fun. What is all this stuff? Presenter overlay. What's this? Oh, okay. I'm gonna stop. I'm about to hit buttons. I'm not gonna do it. I'm out. Sorry, guys. I was about to hit buttons. That was really exciting. Hey, Richard Thornton, how you doing? Megan Fox, what are we doing? Well, hey, you know what? Since you're here, why don't we just hello this? That's what we're doing. Okay, anyway, so all this we're still in the substantive category, right? Because this is 3 pattern behavior extends beyond the simple online thing. This is all part of the third person in a different case, different court, different person. Has nothing to do with Lee's federal. What was this titled as? This is the opposition to plaintiff's motion for leave to amend to substitute parties. It has nothing to do with any of that. Oh, great. Now I lost myself. Page 3, I already did that. There's 1, 2, 3, 4. It's a third party. 5, evidence supporting these claims include timelines, digital communication, and analytics are clearly. There is no analytics data that clearly illustrate. Wicked good. How you doing? Yes, please hit that thumbs up. Oh, look at you. Yardsticks, $2 a foot. Please hit that thumbs up. I appreciate you, Wicked. Thank you so much. Wicked, did you know?
I like turtles.
I do. I like turtles. Of the ninja variety. All right, evidence supporting. This is still at 6. This is the third case. This is the federal. I don't know how to pronounce her name, ma'am, ladies thing. It's sort of the Lando case. It is essential to the court to recognize the seriousness of the conduct and its impact on both individuals. Again, this court, this is a prime example. It is essential for the court. Yes, she is talking about the court in the 9th Civil Circuit of Orlando. This is in the federal Judicial District of Florida, the 9th or the 11th Judicial District, Northern District of Florida. Okay, this is a federal case, and you're talking about a civil case in a state where the court is in there. It's not here. It's not essential for the federal system to do anything. I just watched a video a second ago where a police officer was serving somebody, and the person ran, and he ran him over with his car, and then he was going to be sued, okay, for a 1983 violation. It's civil rights. You denied them their civil rights by running them over with a car. So what the cop's attorney did, he was sued in state court. They removed it. The cop's attorney successfully removed it to federal court. And federal court, because the officer in question was serving a federal warrant and therefore was under the guise of a federal agency, he has protection, federal protection from being sued. Totally different court system. Totally different set of rules. Totally different everything. Miss Lee, you are talking about a third person in a different case. What's the other one? A different court. None of these facts, none of these things that they say matter at all in this federal case. Plaintiffs seek to file a Second Amendment complaint to substitute. Only through legal action can we ensure and soothe and manipulate. The pursuit of truth and the protection of free expression depend on the willingness to expose and address such schemes wherever they appear. 7, plaintiffs seek to file a Second Amendment complaint to substitute Raymond G. Bonebreak for a previous unidentified John Doe, while federal rules of civil procedure allows courts to freely grant leave to amend. It is not an absolute right. Why is she talking about this? To amend is not absolute right. Leave may be denied for undue delay, bad faith, or dilatory motive on the part of the movant. I love that word, movant. I have a hard time getting it. It's stuck in my nasal area, but I love the word movant. Repeated failure to cure deficiencies by amendments previously allowed undue prejudice to the opposing party or futility of amendment. Yeah, what that's saying there is that you screwed up when you filed your original complaint, and because you have all these screw ups in it, you don't get to do 100 amendments to fix your complaint. Campbell very clement. Okay, now we get to an argument. I don't know what all this was. What is all this? If we're just now at the argument. We're just now at the argument? What was this supposed to be then? Introduction? Wow. And again, I'm being critical. I'm not looking at this through the rose-colored lenses I promised I would. Okay. I'm being a little too critical right now, and I apologize. It's a pro se litigant. This is why, hey, Jackson's mom, this is why you don't represent yourself. All I hear is noise, no substance, but just honor my feelings. Yes, you are very much correct, Freckle Ginger. Lady Lysandra, how you doing, babe? What's happening? Al Henderson, what's happening? First comment. Best everyone here. The entertainment value is fantastic. Well, thank you, Al Henderson. And ladies, look at this guy. He's a good-looking guy, man. He looks like he just stepped off. Do you know Wayne Newton? You look like you just stepped off stage with him. Like you're like a Vegas showman. Like that's like the dinner show guys. Like, you know, he's always coming up and hitting on my mom. And I'm like, hey, what's happening? That's why I don't take my wife to dinner shows. Argument. The plaintiffs have exceeded the service deadline. Plaintiffs, now this, okay, this might be a legitimate thing. Let's see what it says. I don't know. Plaintiff had 90 days from the filing of the original complaint to serve the 10 of 11 named defendants. It has now been 113 days since the complaint was filed. Under Rule 4M? Rule 4M? Rule 3M is they use Scotch tape. 3M, Scotch tape. Or just use the Scotch at this point. If a plaintiff fails to serve a defendant within a 90-day period, the district court must dismiss the action without prejudice as the defendant or order that service be made within a specified time. Yes. Okay. So, Ms. Lee, were you served? Because somebody else wasn't able to be served, that does not mean that is not severable from the complaint. Does not mean they are not severable from the complaint. Okay. It means the complaint, because in the interest of justice and making everybody whole, you want the complaint to go forward. You don't want a technicality like, well, Fred over there, he done died. You can't serve him. Nana, nana, boo, boo. Sorry. Hey, Silhouette, how you doing, babe? Let's see here. Plaintiffs have exceeded service deadline. Okay, for the plaintiffs, you must specify time. Plaintiff's failure to serve the defendant. Yes. 11 named defendants. They better serve every single one. Well, some of them, they better be all over 21 or they don't get service. That's only in a bar. That's only in a bar. Guys, I'm going to celebrate Diane's super chat here a little bit. We'll give it a little second. But I want to get through a few more things here because I'm kind of slowing down. I'm sorry. Plaintiff's failure to timely serve all defendants raises concerns about their diligence and compliance with the federal rules of civil procedures. Okay, let me ask you this. Raises concerns. All right, ma'am, what are your concerns? What are your concerns about their diligence? And let me ask you this. Does diligence matter in this case? Is diligence on trial? And compliance with the federal rules of civil procedure. All right. So compliance and diligence. All right, what are your concerns? You have to use words. You have to Use words to communicate. Tell people what it is that you have your problem with. Okay. Again, everything here is nicely written. However, I don't know if it comes to the levels that are necessary. B, Ray's contact information was always available and service has been made. I have no clue what the hell that sentence means. I just read. Let's go back to Diane real quick. Okay, we want to say, Diane, she loves it. She wants it. Everybody, stretch out your arms, okay? Because we got to have a little overture. Thank you. So see, like I'm looking at Jackie Grammy. So like I don't know any of this stuff that you're talking about, Grammy, because it doesn't. Hey, Lisa, yeah, because it doesn't. I'm not. I got other stuff going on, right? Like I mean, I'm just, and that's how the court is. The court's full. The court doesn't know who these people are. They don't care. You know, they care about their next tea time. Ray's contact information is Raymond Bonebreak. Is that a real? That's not real. That's a stage name, right? Contact information was listed in the complaint from the outset. Service has already been filed on the docket for Ray, rendering any argument about the need for unnecessary substitution. Rendering it how? Rendering? Yeah, okay. So I thought that was wrong. So this should be render, not rendering. It was rendered. It was transferred. It's a transfer term. And legal definition of it is anyway. Notable plaintiffs filed. I'm not nitpicking. I'm nitpicking because it's a thing that signals off in my brain. It's fine the way it's written. Okay, don't worry about that. Ms. Lee did a very good job writing this. Again, for I don't know how it is for everything else. I'm seeing double Saturn. I'm seeing double. How many rings does Saturn have? 9. Plaintiffs filed this motion without requesting an extension of time to serve Ray or the other 3 defendants, further undermining any claim that amendment is necessary or justified at this late stage. If Ray is properly served, he or his counsel can request to have his name corrected on the docket. Alternatively, plaintiff's counsel can move to correct the name as was permitted earlier in the case. What is this? How's this the argument? I don't understand. How do we get here? Why are you telling the court what can happen? Well, what? What is happening here? Ray's background, the character of this lawsuit, and the lack of personal jurisdiction. He's an 80-year-old. Age doesn't matter. Being disabled doesn't matter. And being a veteran doesn't matter. He suffers from Cop D. I know a girl that suffers from their mind. Sorry. And other health concerns, and who fought for his own rights and the rights of all Americans. Why are we removing her from this complaint? What page are we on? 7, and we don't know why we're removing her yet. To adding to this frivolous lawsuit, which appears designed less to seek justice and more to silence anyone. Like, this sounds like a Nancy Grace episode. He fought for his own rights and original Americans. Adding to this lawsuit, which appears designed less to seek justice and more to silence anyone who differs in opinion from Mr. Hales, and his use of the YouTube channel to destroy reputation is wrong. The court didn't sue him, though. See, the court didn't do anything. The court listens. This lawsuit has not only caused needless harm to those it targets, but it also made a mockery of the federal court system. I could say something right now that I'm reading. Anyway, by turning it into a personal stage for profit and spectacle. Oh, I'm making it. It is a spectacle. I will tell you this 100%. This whole thing's a spectacle. She does have that right. And I'm just an idiot reading words on a paper. Federal courts are not meant to be used as tools for intimidation or entertainment. That is correct. Now, this is the part I hate. So, like, you see how you have double spacing and all this? And then you have double spacing to see. I'm a fan of single spacing. Single space things. I do like 1.5, maybe. It's been a long time since I wrote anything. Florida does not have personal jurisdiction over Raymond Bonebreak, and he is not a resident of Florida. It has no meaningful context with the state that was subjecting to jurisdiction here. Yes, so that's why we're in federal court, because federal court does have jurisdiction over him, okay? That's why it's in federal court. Diversity of jurisdiction is one of the reasons. And a cause of action over $75,000. This is how you get into a federal court. Or what's the other way? It's a federal question. And then the third way is if it's two states suing each other. You got that? Yay, we're learning. So this is in the right court. Personal jurisdiction requires that a defendant have minimum contact with the forum state, such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. Okay, here's the thing. Go see what Liciardello versus Lovelady. Go see what that case is about. Just taking a line out of a case doesn't mean that it's dicta. Adding Ray as a defendant under these circumstances would be improper and subject him to unnecessary hardship. Is this Lee person? Is this Nancy Grace? We're gonna call it Nancy Grace from now on. D. Plaintiffs abuse of the legal process and shell tactics against slap. And stall tactics against anti-slap motion. Oh, wait, hold on. Let's see here. I just saw somebody say hi to somebody. I want to see what's up. Oh, thank you, Elfie. Military experience means nothing about character. True. Hey, Squid, how you doing, babe? How's it going? This is hard to read. It's really easy to read. I'm goofing off, Meg. As a story, it's a good, you could take this whole thing and be like, you could extrapolate it from it and give it to somebody and say, this is what's been going on. Got it? But as a legal process, no, because we're still not talking about, she's not talking about herself. She's just giving an overlay. This is like a journalist. Hey, do you know a journalist, Meg? No, she is like Nancy Gracing this. So, she's like that whole like tonight on Nancy Grace. Blah, 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 blah. That makes sense what I'm trying to say. Let's see here. Hey, Bunsen, how you doing? I've always liked Rockin' Stone as the name. Diane. All right. Let's see here. Jeremy Hales has made it clear, even on his own YouTube channel, that he does not take people to court to win on merits, but to bankrupt those that oppose him. I really want to see that quote. I've heard that so much now. As recently as last week, after a Zoom hearing before Magistrate Bolito on a related case, and again, I think that's the other guy in federal court, the other judge. Yeah, different case, different judge. Each judge has their own rules. Was it a good attorney knows the law, a great attorney knows the judge? Mr. Hales publicly said that he has no intention of mediating and that the only way he will settle is if defendants President Cook leave Otter Creek, Florida and sign everything they own over to him. I don't know if that's what that's about. This further demonstrates that his true aim is not justice, but to obtain property he was unable to acquire himself and to punish those with whom he disagrees. Moreover, defendant Lee believes this motion that's who we're talking about. That's who wrote this. Believes this motion to amend is a transparent stall tactic designed to delay the court's consideration of the pending anti-SLAPP motion, which by law is supposed to be handled expeditiously. Okay. Is there a federal anti-SLAPP statute? I'm unaware of it, if there is. I don't know anything about SLAPP. Okay. The only slap I know is a bitch slap, pimp slap. Pimp slap, you use the back of your hand. Bitch slap, you use the front of your hand. Pimp slap, bitch slap. James D. Oh, wait. Rick D's taught me that. James D. That's somebody else. That guy, man, he didn't teach me anything. I don't know if there's a federal anti-SLAPP. Yes, this is. Yeah, that's the odd part. That's why I said it's like a narration. This is a narrate. I got it right the first time. A narration. A narrative. This is a narrative of the case. This is not really a legal proceeding or filing. However, though, Megan, like I said at the very beginning of this, I will read this in as favorable as I can because that's how federal courts are always trying to be favorable towards pro se litigants. So you want to look at them and you say, okay, well, you kind of that little like, bless, whereas with attorneys, they expect a higher level of standards with them. They expect better. Anyway, and the pro se litigant. I mean, here we are. This is Liberty Month. Next month's signing the Declaration of Independence. We do respect the pro se litigant in America very much so, and that's why I'm trying to be good. But it's hard for me because this is not read well as a legal document for me. So, but yes, it is weird that she did not argue on her behalf. True. Thank you, Megan, for being here. By the way, love you, babe. Keep the pimp hand strong. A slap. Get it? It's like slap and a slap. Yeah, keep that pimp hand strong. Well, I said slong. I'm loony. All right. Expeditiously, plaintiffs repeated amendments and procedural maneuvers in this case and a related case are not only a waste of judicial resources, but also hold defendants' lives hostage by prolonging litigation and chilling their right to free speech. If that was reworded just a little bit, that'd be a good sentence right there. For me, I would say like chilling their right to free speech. Like, so you say, just the totality of this case has a chilling effect on the rights, the individual free speech. I like that sentence. Courts in this circuit have recognized their inherent authority to prevent the abuse of the judicial process. Okay. And that's it. It just ends. Hey, you know what? I'm really proud that she cited cases. I mean, that's a win. That's a big win for most people. And cited properly, actually. Abbott v. Singletary, 105 Federal 3rd. That's where it was put into law at 610 at 613. So 105. So when you look for the books, Federal 3rd is what the section looks like what are those things called? Like an almanac. You find the 3rd, you go in there, you find 105, and you go to 610, and you go down on the side, it'll say 613, like 4th, 5th, 6th, whatever paragraph. And then this is for the 11th Circuit, which we are under here in Florida. And 1997 was the year of the ruling. So when you look at 97, you think to yourself, okay, is it still good law 30 years later? But this is how you cite cases. That was a good site. And all of our sites are good if those are to real cases and stuff. Sometimes people Google them and they get them wrong. Attorneys do that. So E. Now, this is her argument still. Section E. Concerns about plaintiff's motives for amendment. Concerns about plaintiff's motives for amendment. What are your concerns? Tell us your concerns. What are they? This is the plaintiff's second attempt to amend their complaint. Given the timing, after motions to dismiss anti-slap motion have already been filed, defendant Lee is concerned the plaintiffs are using the amendments as an opportunity to add allegations or state claims based on recent motions to dismiss or parties beyond simply substituting Ray. Well, I hate to say that, but like this is something you bring up once they do it. This would be an objection statement. So defendant Lee is concerned that plaintiffs are using this amendment as an opportunity to add allegations or state claims based on recent motions to dismiss or parties. So you have to let them file that first. You can't assume that that's what they're going to do next. Because like if you assume I'm going to do something, then I have you, because I'm not going to do that. I'm going to do something entirely different. So you're running over here assuming something, and I'm going to go this way around you, and you just go, ha, I'm up here now. I didn't do the way you thought I was going to do. I outthought you. Sorry. And let's see here. We have a Rickles says, including the right to talk themselves into trouble. Ooh, anybody can do that. That's a good one, Rickles, and anybody can do that. That's why I always tell you guys, be careful what you say in chats. That's a good one. Thank you, Rickles. And Diane, give the 10 memberships. Thank you so much. Guys, you got to get in there and hang out with us. Go into Discord, and also Sundays, I do members only stream Sunday nights. And then sometimes through the week and stuff, like I try to release, if I do videos or shorts, I try to release them first to members. But also there's a link to the Discord, and you can come in, you can hang out with us. And on Sunday nights, I'm always in there. And on Sunday nights, you have the right to, you can tell me anything you want to. You can say how bad I suck and how bad I am at it and everything there is. So thank you, Diane, for the memberships. Go back to the live chat here. Santiago Garcia Jr., how you doing? I'm so glad Al's come out of his shell and talking to people. He's a cool guy. We got to keep him around. Hey, Cajun Joe, what's happening? I love the avatar. And crawfish and shrimp entrails. Courts routinely deny Courts routinely deny leave to amend where the amendment is sought for strategic reasons or to circumvent pending motions, especially when it would cause undue delay or prejudice. See Maynard v. Board of Regents and of the Division of Universities of Florida's Department of Education. I mean, that's a site. All of the right. Ooh, in bank. I did an in-bank once. Ooh. Anyway, went up. When a plaintiff seeks to establish a defendant after the statute of limitations was run, the amendment may only relate back if the requirements of Rule 15C are satisfied, including notice for the defendant that the failure to name the proper party was due to a mistake. Wait, hold on. I forgot. We were talking about her argument about why she shouldn't be in here. There's nothing to do with that. She's not, none of this stuff has connected to her. We're on page 10 here, and nothing's been talked about herself. Prejudice and futility, part F. Allowing further amendment to the stage, especially after the service window has closed. Well, we don't know if that has closed, though. Remember the whole thing when I was talking about severability? She was served. She needs to worry about herself. She does not need to worry about other people. Other people, man, let them fend for themselves. Because you know what? They will let you fend for yourself. Service window is closed, and with dispositive motions pending, would prejudice defendant Lee and impose unnecessary delay. Plaintiffs have not shown that the claims against Ray relate back under Rule 15C, nor have they provided a proposed amended complaint as required by local rules. C. Wagner, affirming district court's discretion to deny leave to amend when amendment is futile or would cause due delay or prejudice. So this is the second time in this. She's talking about amending a complaint. It's just wrong. Honey, you can amend complaints, okay? That's okay. You need to focus on yourself here. Why do you need to be not sued? Why are you not liable for any of these things? You haven't addressed a single thing yet that Hales is suing you over. You need to address it and say, none of this is actionable. This is all, there's no relief here. There's no relief. There's nothing to be done. Wrong. It's out of here. Guys, I think, who was the other one I read? I read one of these. The first one I read. Was that Hales? It was really good. She should have gone back and just taken that argument. But here, who cares about the stuff you're saying? Doesn't apply. Cancel for plaintiff Randy Shockett. Randy Shockett? Oh, excuse me. No. Oh, sorry. There's comma. Has defendant Lee listed in document 58 on his service list. Defendant Lee has not received this document via email or United States Postal Service. Mr. Shockett has 2 emails with which to contact defendant Lee and has not used them. Oh, so she's saying that she wasn't contacted? If you weren't served, why did you answer the complaint? Says you answered, you're served. Shockett. Oh, wait a second. Oh, this is Diane. I remember her the other day. Shockett or Spockett? Sorry. Diane, thank you so much. Look at you. I wish I could do the fireworks out here. Oh, my gosh, you're killing me. Not always shocking. What are we talking about? Oh, yeah. Let's see here. Oh, wait, I gotta get back here to comments. Turn them on. Sorry, guys. And document 63 for plaintiff states that a certificate of good faith conference claiming to have conferred but unable to completely resolve the issues presented in the motion as follows. Ooh, this was see this, how this messed up here? That's this sentence, okay, here's the thing. So when you have a long quote like this, what you're supposed to do is right here after follows, you should do an extra space, and then you bring in your margins. So this should be tight, and your quote should be single space, tight in the middle. Sorry. This is Blue Book procedure. Do you guys know there's mine's right over there. There's there's a spiral Blue Book on how to write. Megan's probably got a Blue Book she probably has the AP Blue Book. Ask her sometime about hers. Let's say the expert wants to see your spiral notebook. No, don't say things like that. Pursuant to Local Rule 7.1, I hereby certify that counsel for the moment has conferred with all parties and non-parties and who that may have been affected with the relief sought in this motion in good faith effort to resolve the issues, and defendants Maskin and Helm have no objection to this motion. But the defendants Lee, Preston, Cook, and Hughes, the undersigned has been unable to resolve the issues. This information, so see, then this right here at this, that would be another paragraph. This is a grammar issue. This information is false. Brandon Shaka has not contacted the defendant to confer via email or. I think Local Rule 7.1, if I remember off the top of my head, didn't we discuss this before, where 7.1 is that you have a duty to mitigate your case? I think that's what it is. Anyway. Shaka has not contacted defendant Lee to confirm anything. Additional on document 63, defendant Lee is listed on his service list and has not received a document related to this case from plaintiff's counsel. But you're answering it, honey. Baby doll, listen, Miss Lee, don't. Okay, you just answered it. So guess what? You've been served. There's a thing called constructive service, guys. I just don't run around here. I hate this whole like, you got to serve me. You got to catch me. When you do that, okay, when people are doing that, you're making a mockery out of the legal system, and judges don't like that. Man, they don't like that at all. And they will find a reason to show service. I mean, if you know about it, you're talking about all this other stuff, you might be served. It's not a gotcha game. It's not a hide and go seek. Nothing in the law is a game. How do I reach these people? You guys ever see that South Park? How do I reach these kids? Sorry. So yeah, you've been served and you've answered too, by the way. Defendant Lee respectfully requests that the court take notice that only contact had inquiry about agreeing to defendant Lee's motion to extend time. Only contact Mr. Shockett was his response to defendant Lee's inquiry about agreeing to defendant Lee's motion to extend time, which Mr. Shockett discourteously declined. No, you don't have any more time. Well, he doesn't have to give you more time. Defendant Lee believes his lack of communication is intentional and requests the court ensure she is notified of all related court documents accordingly. You are. The court should also be aware that considering the attached court decision from the Supreme Court of Arkansas, the Florida Board of Bar Examiners has been alerted to the appearance that Mr. Shockett may have omitted from his Florida bar application the information detailed in the Arkansas court decision. Arkansas court decision. It is unknown if an investigation will be undertaken or if such would impact this case. What? The court also should be aware that considering the attached court decision from the Supreme Court of Arkansas, the Florida Bar Examiners has been alerted to the appearance of Mr. Shockett may have omitted from his Floyd bar confession the information detailed in the Arkansas court decision? Is this a smoking gun? Is there a smoking gun attached to this? For these reasons and pursuant to the authority above, defendant Lee respectfully requests that the court deny plaintiff's motion for leave to amend complaint and substitute party or the alternate require plaintiffs to provide a detailed explanation, proposed amendment complaint, and clarify that the amendment is limited solely to substitution of Ray and not introduce further changes. No, ma'am. I'm sorry, babe, but I don't think that has anything to do with what you're talking. I don't. Sweet baby Jesus, I feel like I have failed you again. Why am I submitting these people to this? I apologize. Sweet, sweet baby Jesus, my favorite of the baby Jesuses. I promise I am not intentionally doing this to you. I do not want to disturb your sweet little manger. Baby Jesus, sweet baby Jesus. I also wanted to thank you so much for those hush puppies I have at dinner tonight. I love those hush puppies. I love hush puppies. They're so good. Thank you, sweet baby Jesus. I'm so sorry. I will try again to do better. Sweet, sweet baby Jesus. He can only listen to so much. Makes you want to. Jeez, man. You should have been all right. All right, let's see here. So hang on. Let's find out here. Let's go look down here at our evidence. Okay, so then there's a whole bunch of things here. There's an extension. Dear counsel, please let me know if you can send to a 30-day extension of time to the amending complaint. No, that's not how you do that. Anyway, Shockett versus Arkansas Board of Law Examiners, 1998, 30 years ago. So I'm going to guess. Oh, no, here's a big shocker. A law student sued the Board of Examiners. Do you know how many people have sued the Board of Examiners in states? You know what they usually sue over? They usually sue over the fact that they didn't get a good education because they should have been told, don't go to law school. I kid you not, man. It's the funniest thing. It's the funniest thing. Let's see what this gem is. Oh my gosh. Now I'm excited. Let's see here. Oh, wow. So we got all this attorney-client. So this here, opinion delivered. The applicant has the burden proving eligibility for admission to the bar of the Supreme Court and must do so by the preponderance of the evidence. Supreme Court reviews bar admission and reinstatement cases de novo. And will not reverse the findings of fact the Arkansas Board of Law Examiners unless they are clearly erroneous. Oh, wait a second. Oh, that's not even the. Oh, it's funny. Oh, you paid for this? All right, this is not. Where is the beginning of this thing, though? Oh, here you go. So all this, okay, and this is I'm glad this is a Westlaw, okay. Thompson Routers, they own Westlaw. So this is like a synopsis of the case right here. All right, you got to go down here, Newbern Justice. Let's see, it's an appeal, blah blah blah, and we go down here. Okay, this is the opinion of the case. This is the way it's submitted from the court. So all this over here is the like what are those things called? The clips. Were those the little things? Side clips? I don't know. Anyway, let's see what Shockett and the Board of Bar Examiners did. As an appeal from the decision, Arkansas Board of Law Examiners denied the applicant of appellant Randy Shockett for admission to the bar of this court. Mr. Shockett has completed the necessary education requirements, and he passed the Arkansas bar examination in 1996. The board determined, however, that Mr. Shockett failed to establish good moral character beyond a preponderance of the evidence as required by Rule 13 of the Rules of Governing Admission to the Bar. The good moral character part, okay? Like, oh, man. Gosh, man. Good moral character, and this is giving me PTSD. So you have 2 times you have to face this. One is your application to law school, and the second time is your application to the bar. And usually the bar is very, very strict. So they're exposing? How is it? Angie says, Cliff Notes, by the way, Cliff Notes. Yes, Liz, thank you so much. Angie says they're exposing what they think will disbar him. Oh, this is this case? Well, let's see what happens here. Because I'm sure, well, you're telling me that Randy passed the bar in Arkansas and Florida? Do you realize that you can be disbarred and you can be disbarred in one state and take it in another state, I think. You can't do it with an intent to, mislead or whatever else, but I forget what it is. I don't know. These are my problems. I don't practice law. I don't do this stuff. All right, let's see what it says though. So the good moral character denied his application. Well, it was that Vol VOL Shock and Spocket. Do you want me to play the difference of it? Diane, are you watching? This is a shock. All right. And this is Spock. MQ, I know that my brain did, but hey, look at this. Our avatars match. Sorry. That's what I said too. Oh, last words right before. All right, where are we here? What's happening? So this supposedly, evidently, people think this is going to get them disbarred here. Let's see here. Ms. Shaw could argue. Let's see here. So he didn't pass the good moral character preponderance of the evidence required by the bar. Mr. Shockett argues on appeal that the board's findings are conclusions underlying its decisions are clearly erroneous. We affirm the board's decision. So the Supreme Court says, yeah, we agree with the board. Mr. Shockett attended dental school in Florida after completing his undergraduate. He later moved to Missouri, where in 1986 he obtained a license to practice dentistry. 1990, the Missouri Dental Board filed a complaint before a state administrative agency claiming that Shockett in 88 and 89 had billed an insurance company for dental services he had not rendered. Oh my gosh, in 1988. Oh my gosh. Let me tell you what. Okay, so there's a band called Steel Panther, and they have a song called 1987. And 1987 was the greatest year of rock and roll ever. That's all I know. And I think, was it the Pour Sugar on Me, Def Leppard album? It was like touring in 88 or something. I mean, hit me like a bong. All right, so so 2 times he billed an insurance company and not provide done services. The dental board also claimed that Shockett had provided his officials with false information during their investigation of the matter, and that he had committed perjury while testifying before the dental board. Now, perjury is the only thing that matters here, if you ask me, because perjury, you can't do that. It's a legal term, right? As far as dentistry, I don't know. What is like filling out numbers with insurance companies and drilling teeth have to do with practicing law? It does have a lot, but still. So I got enrolled in St. Louis University School of Law in 91. Oh, so he's like, oh, I like this law stuff. In 92, him and the dental board resolved the matter described above. The dental board abandoned its perjury charge. And Shockett admitted he had billed an insurance company for services he had not rendered. Shockett accepted a 120-day suspension of his dentist license commencing in April for Fool's Day. In March, prior to the commencement of the suspension period, Shockett entered into an agreement with Dr. Glenn Yowell, providing to assume Shockett's dentist practice. The agreement provided as follows: Shockett agrees to furnish the dental facility located at, including all equipment. Oh, yeah, give all that stuff in exchange for an amount to be mutually agreed upon. Such reimbursement shall not be measured against patient fees and billing. It is not fee splitting. It is only based on a usage of the dental office. Dr. Yao is to provide his own professional liability insurance. Our relationship may be terminated on either side by giving the other 3 weeks' notice. Shockett and Yao signed a separate document, a letter dated in 1992, March 9th, 1992, written by Shockett that reflected further details of their arrangement. Shockett referred to Dr. Yao as an independent contractor dentist and indicated Dr. Yao was to perform dental services on a patient. Oh, bye, MQ. I'm sorry I'm not cool enough for the other kids, but you guys have fun. I mean, I can send everybody over there in a second. All right. And I thought we shared a Muppet balcony together. The letter revealed that Mr. Shockett would pay Dr. Yao a sum equal to 20% of the collections made for his billable services. You know what this reads like? This reads like something from law school. So like I think Shockett may have like taken a class and like, oh hey, I should add all that stuff into it. Shockett returned to his dentistry practice at the conclusion of suspension period. He completed a uniform application for securities, blah, blah. The Missouri Dental Board filed a second complaint against Shockett, alleging he had practiced dentistry during the period in which his license was suspended. The Dental Board referred to an agreement between Shockett and Yao. It alleged that payments from patients or third parties received for work done by Yao and Dr. Rivera had been deposited into a bank account, which it was in the name of Shockett. But that doesn't mean he was using his license. Shockett had submitted claim forms of insurance companies and had received payment for dental work rendered during the thing. The dental board alleged that Mr. Shockett's conduct violated regulatory provisions that prohibited a suspended dentist from receiving Man, I tell you what, these boards are tough, man. From receiving any compensation from any person, group practice, partnership, or corporate practice, or any dental office in the state during the period. So here's the thing. So what young Shockett did, where he screwed up, is he should have had this approved by the dental board before having Yao sign it. I love you, Diane. That is right. 100%. We're going to leave that one up. The dental board alleged that Mr. Shockett's conduct violated regulatory provisions and prohibited citizens from dentists from receiving any compensation. Mr. Shockett assumed his legal education at the University of Miami at Coral Gables School. Miami, in Coral Gables School of Law. So is that in Florida? Shockett and Missouri Dental Board resolved. I mean, can you imagine being in Florida though, and in school, especially like law school, and trying to do something in Missouri? Oh my gosh. October 94, Shockett and Missouri Dental Board resolved the matter as alleged practice upon suspended license. The Shockett admitted to the Dental Board's allegations, surrendered his Missouri dental license. Shockett completed law school and earned his JD. Shockett applied for admission to the bar of this court in 896. Mr. Shockett was allowed to take the court. So, okay, well, from Missouri to Florida to Arkansas, this smells like there is a woman involved. By vote of 10-1, the board determined that Mr. Shockett failed to establish by preponderance of evidence that he had possessed good moral character. Wow. Mr. Shockett was allowed to take the July bar exam, subject to a continuing character and fitness investigation in the event that he passed the examination, which he did. The chairman of the Board of Law Examiners was unable to determine Mr. Shockett's eligibility, and Mr. Shockett appeared pro se at a hearing before 3 members of the board and the board's executive secretary. That was stupid to show up pro se, as we have learned. By vote 10-1, the board determined that Mr. Shockett failed to establish things. The board based its conclusion on one, the facts surrounding the suspension and surrender of Mr. Shockett's license, and the explanation of the situation of the board during the hearing. Two, Mr. Shockett's response to the questions on both the Arkansas bar character question and application for the Series 7 securities license, as well as his explanation of those responses were made during the hearing. And three, evidence that in the board's view demonstrated Mr. Shockett's lack of fiscal responsibility. Mr. Shockett now seeks reversal of the board's decision and maintains that he established sufficient good moral character and should be admitted to the bar. Holy cow, man. Fiscal responsibility? Jeez. I mean, there's a lot of people that have. There's a lot of people, attorneys that just, you just can't commingle funds and you can't mess with trust and stuff. I mean, but it's like money is the thing that gets you thrown out as a lawyer. Nothing else does. You have to have, while practicing, you have to screw with patients with clients' money. He told the board's findings they are not clearly erroneous and affirms the decision denying Mr. Shockett's application for admission. Let's see here. The Missouri dental license, that doesn't matter. He lacked the financial resources to defend the charge. He saw no purpose in defending the charge because he was living in Florida and attending law school there. He did not intend to use his Missouri dental license. Well, I mean, those are all good reasons. He wanted to foreclose the possibility of having his the possibility of having his license revoked. I got you. The board found that Mr. Shockett now denies responsibility for practicing dentistry while his license was suspended. Oh, so he was practicing with no license. That's what they got him to. Record shows that on January 15, prior to the beginning of the suspension period, the applicant's attorney set forth the circumstances under which the applicant could rent. Who cares about rent and stuff? The board. So right here, it's also prudent for the board to take into account Mr. Shockett's practice of dentistry on a suspended license. Misconduct that Mr. Shockett acknowledged in administrative proceedings in Missouri. In the hearing before the Arkansas Board of Law Examiners, however, Mr. Shockett denied responsibility for his misconduct. That's what got him in Arkansas. So in Missouri, he admitted to it. And in Arkansas, he said, no, I didn't do it. And you know what? Let me tell you, you know where he screwed up? He was a law student. Okay. He's a dumbo like me, you know? Doesn't have anything to do with anything else. It has nothing to do with this case. It has nothing to do with anything. I have no idea why this is here. This is long and boring, and all it says is, let's see here. What's the final conclusion here? The board will conclude that Mr. Shockett has engaged in false and deceptive practices in completing the various applications. This is in 96? 30 years ago? I mean, you know what? A lot of people aren't even a gleam in their daddy's eyes 30 years ago. In 30 years, you can have almost retired. No, that's not 30 years. So let's say you join the military like 17 or 18, and you do 20 years, full service, whatever. You're retired at 38. That's a lifetime, man. Government pensions are 20 years. Think about this. He could have already had an entire career and retired in this amount of time. This is dumb. Hey, General T, what's up? Joseph Willman, what's happening? Joe, how you doing? There you go. That's it. You retired. Military, police, fire, everything. Hey, awesome. That's great. That's awesome. You'd be retired. So, yeah, look at this. I have no idea why this is anything. There's a mailing label and nobody cares. Why did you submit this to court? You submitted a Nancy Grace scenario. Dude, I don't know, man. I feel bad. I'm sorry I put you guys through this. Baby Jesus is going to have to get me. This is the time on Shockets when we dance. Wiggles. Wait, hold on. Are you talking about like... Wiggle, 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 yeah. Wiggle, 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 yeah. Wiggle, 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 wiggle. My dogs wrote that. Oh, you have good dogs. Woohoo. All right, guys. Here you go. Because here's how it is. Oh, Tug's got more people in his chat, so I got to go over there. I can't support small guys. I got to go support the other ones. So I'm going to send you guys over to him. Okay. Calm down. We're going to go in there. When you go in, whoops, that was the wrong button. When you go in there, I want you guys to all throw up, not throw up, but like, put like orange hearts and stuff, right? Does that make sense? Let me do this. Let me do the how do you do edit video? We're gonna go over here. Okay. Don't leave till we do this, so that way he gets the big bump from YouTube. If you leave now, you hurt him. So I don't know what you're doing. But anyway. Yeah, there you go. You want the big jump. So that way he gets all that. And it's a big YouTube thing. You go there and you put a bunch of orange hearts in there and say, woohoo, yay for you. Look at it's your lucky day, Tug. So, hey, thanks for coming out, man. Enjoy your first visit. I'm so glad you're here, Al. Hope you come back Friday nights, Friday Night Live. Best show with your pants on. No, you don't wear pants on Fridays. Ooh, all right. Anyway, I know, Liz. I love you to death. I love you to death. Oh, actually, hold on, wait. If Saturn's still here, by the way, you gotta see the art that Liz does of speaking of like Captain America. She does all these she's a great artist, absolutely great artist. Guys, be good or be good at it, and don't forget. Don't forget, you got to shock it before you spock it.
I woke up to go get me a cold pop, and then I thought somebody was barbecuing. I said, oh, Lord Jesus, it's a fire. Then I ran out. I didn't grab no shoes or nothing, Jesus. I ran for my life. And then the smoke got her. I got bronchitis. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for somebody was